Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. Hello. Good morning, good afternoon, good evening, wherever you are. I hope you are having a wonderful start to your week. Happy Tuesday, everybody. So I am, as you can tell, not in my usual YouTube studio. I am in a hotel room in Germany. I'm traveling with Mr. Bites. And so I still wanted to keep up with the usual content. And I've made a commitment to have content at the very least come out on Tuesdays and Thursdays at 10 a.m. East Coast time. So whether that is live streams on Tuesdays or pre-recorded, I'm not sure. But of course, it's a minimum, so not a maximum. So, wanted to keep to that. I don't know. What do you guys think about the name Legal Tea Tuesdays? Let me know in the chat or in the comments if you are watching on replay. And just a note, I am operating off of one screen and I feel like I'm half blind because I normally have two screens and I already feel like I've always felt like two screens is not enough. Like I really could probably operate best on like 16 screens all at once. So, but anyway, let's get some hellos from folks all around from a bunch of places here. I see folks in the chat here. Let's see here. Alrighty. We've got Aaron H. Good morning from Orlando. We've got who else here? Miranda Hike. I'm sorry. I'm totally butchering your last name. I know it. But good morning from Michigan. We've got Cross Stitch Phoenix from Southern Utah. Awesome. And who else? We've got some more folks. Oh, we've got somebody from Normandy, France. We've got from Yakima, Washington. Afternoon from Germany. Have a great vacation time. Thank you so much, B. Guten Tag, as they say. I'm sure I'm probably not pronouncing that very well, I'm sure. Pamela C. from Arizona. We've got Howdy from Houston with Karate Cat Mom. Karate Cats are awesome. I love it. I love that name. Alberta, Canada as well from Hez01. I love it. Also, Nathan C. Welcome to Bike Club. Happy to have you here as a new YouTube member. Love it. And 2012 Davidson sponsored by Dragon's Treasure. I actually didn't tell Dragon's Treasure Teas that I was naming this live stream from this, but I mean, sure. There is an affiliate link in the description below, so I do make a nice little profit from there. It does help support the channel. So if you are interested in trying some really great teas, there are some great options for you. So, alrighty. Oh, we've got another person from Germany. Hey. Andy Smee, love it. Love to see you here. And also Nathan C. is from Alexandria, Virginia. Alrighty, so let's get into some of these topics. I just, it's one of those weeks where I just decided I needed another like group live stream to kind of like talk about a number of topics all in one stream. And I'm going to try to do a better job of time stamping all of these subjects because I know that these get really long. Sometimes people are more interested in one topic or another. So I'm going to try to keep track of those and then update the timestamps either while we're going through the live stream or maybe afterwards. I don't know, I'll figure it out. But I really appreciate seeing all your lovely, wonderful faces in here. I mean, you can't see your faces, but you know what I mean. I'm so happy to see you guys here. So we've got Adnan Syed. We've got Taylor Lorenz. We've got Ashley Morgan-Smithline and her whole attorney-client relationship issue that is going on here. But first, I mean, I know there's been a lot of legal tea in law tube, so to speak. Um, over the weekend, I mean, those of you that follow us all on Twitter know that we have been pretty vocal about the folks at Bot Sentinel and a recent report that came out that was talking about misogyny on YouTube and targeted harassment and then also copyright violations, which actually the copyright part was the part that I had the least bit of a problem with on that report, because it just seemed like, okay, yeah, it relatively tracks. Like these at least the few videos that I clicked through and kind of compared to the article that they had linked to, it looked like it was actually verbatim, basically just a recycling of an article that they didn't cite to, didn't direct any sort of attention to. So there was that, but there were a lot of issues that I had with that particular report, and we've talked about them before. The biggest one for me, I mean, there's also, I mean, a number of issues. Like I said, there's the misquotations, the stealth edits that we went through, the edits of the quotations that were by that umbrella guy in particular, and then there was of course the thing that really gets me here is the lack of definitions of terms of art. So when you're using particular terms of art, whether it's in a legal context or a medical context, or really, I don't know, like anything, right? It's important to define those terms. For example, the term homicide can be different if we're talking about the legal definition of homicide versus the medical definition of homicide, on an autopsy report. So in an autopsy report that says that somebody died by homicide doesn't mean that the defendant that is, that has this autopsy report introduced as evidence against, that they actually did commit homicide in there, right? There's a whole bunch of stuff that has to be proven in a court of law. So we're talking about these definitions that are used from time to time. There's a lot of sort of impressionistic paintbrushes going around in this report that are incredibly problematic, because what's being called for is reforms and legislation, and it seems that the positioning here is for a repeal of Section 230. If you're not familiar with Section 230, this is the legislation that basically allows platforms to moderate their content and allows people on those platforms to moderate their content. It's what allows you and me to delete a tweet or delete replies to certain comments on these various platforms, and without running the risk of possibly a secondhand defamation claim in a lot of cases. Now, of course, we're all fully responsible for the things that we say individually on these social media platforms, but so of course from that has been a lot of some interesting spiciness that has resulted, and so many people have made videos around LawTube about this. Eric Conley, thanks so much for your super chat. Hashtag Bouzy Bucks. I know that this has been something that has definitely come up, so let's talk about it a little bit here before we get in, because it fits into the Taylor Lorenz article that we're going to go into about misogyny, harassment, targeted harassment, this kind of stuff. And as a female creator, I have thoughts on that, right? I mean, just as a creator on the platform, never mind the fact that I'm a woman. I have my own unique experience, but that doesn't mean that other people that don't have my experience can't have thoughts about this particular line of thought, what have you. Okay, let's take a look here. Okay, so here's something from Mr. Bouzy. What has resulted from, I should say this, what is one of the things that's resulted from a lot of the critiques that came about from this report was a certain blossoming of intense rhetoric from Mr. Bouzy. So it started with just talking about the report, talking about the issues in the report. Ian had a fantastic video on the report, Ian Runkle, where he talked about the issues with how those quotations showed up in the report, quotations of that umbrella guy during the Depp Heard trial, the fact that there was little to no context, actually there was zero context, really. There was no context other than a link to a live stream, which was, I don't know what, like 10 hours long. We're talking about these trial streams that lasted so incredibly long. If you've been watching this channel for, since around April, or, April through June, if you saw any of the content on this channel, you know that there were a lot of very long live streams where anyone could go in and cherry pick certain things. And if you piece them together in ways that are not contextual, you can make things look really, really bad. There's a lot of ways to do that. So then, of course, Mr. Bouzy goes on Twitter and he starts to target Ian, and he starts to, talk about, basically say how he's just rambling on and on about quotations and misrepresentations, and none of that makes any sense. And yet he then goes and stealth edits his report without any indication that it's actually been edited, and then he got kind of the fashion. And then he turns to Joe, because Joe Neerman, good logic, he also has his commentary on the report. He's got his thoughts on it. And then he turns and starts talking about how Joe, I can't remember exactly what he said. Something, I mean, all of these tweets have been deleted, by the way. This is an interesting tactic that he has, is that he tends to talk about individual content creators that are talking about him. He has these tweets that basically sends a flood of his followers to these individuals to basically talk a bunch of smack to them and try to take them down on Twitter. And then he goes back and deletes his tweets for some reason. And I'm wondering if maybe that's so that he can maybe not be detected by Twitter's harassment policies. I'm not sure, but it looks like he engages in what looks to a lot of people like targeted harassment. He has the whole full threads, and who knows, maybe he's going to make a thread about this particular conversation. I don't know. Somehow I have eluded being blocked by him, whereas pretty much everybody else within LawTube has been blocked, targeted in a thread, or something along those lines. I mean, even Emily D. Baker, I think, has been blocked by him after having like one or two tweets, and like that was it. Like nothing really even getting close to this conversation. So anyway, so it basically goes to Ian. He then goes to Rob after Rob pulls up a bankruptcy report. And then after that, he targets Nate, and then he says that he's going to target Nick. And then he's basically indicating that he's going to go down the list and go through all of LawTube. So we'll see where this actually goes. But yeah, it's been very interesting, the kind of stuff that he's been saying. So let's take a look at a couple of these. I don't want to spend too much time on it, but we'll do a little bit of this here. So here's an example. So after Nate really dug in to respond to Chris Bouzy, then Mr. Bouzy turned his attention to Nate. So one of these tweets here was talking about how Nate was monetizing his conversations. Look, this is I don't want to say, look, this is what we do, but our channels, we dedicate a lot of time and attention to our channels. We provide legal commentary, we provide legal education in a lot of respects. We help guide people through these topics that are in the news, that are trending, that are catching people's attention. And the goal here is to educate people and to inform people as to the law. And so when people give us super chats, on our live streams, we don't beg for those. As far as I understand, I have never personally asked for super chats. There are times where people don't super chat much, and there are times where people super chat a ton. And it's because they want to give what they would like in appreciation for the content. And there's absolutely nothing wrong with that. Now, so he takes issue, Chris Bouzy takes issue with the fact that Nate is going on a live stream talking about him, and he's gathering Bouzy bucks, as was referenced earlier in this live stream. that Eric Hunley screenshotted, excuse me, super chatted me earlier. Anyway, so here it says, I had the opportunity to talk to a reporter about the targeted harassment I have received from a group of YouTube quote unquote lawyers and their followers. One is on a live stream raising money from his targeted harassment, calling it Bouzy bucks. This is how toxic YouTube is. All because we published a report on targeted harassment, etc. So the way they are trying to debunk the report is by checks notes engaging in targeted harassment. This person is a lawyer and he should know better. But this is what YouTube is allowing. At least one person spoke up, and then they've got this, Nate, your behavior disappointing on so many levels. Look, now that also could very well be sarcasm. Sometimes sarcasm is a little difficult to read, especially if you are unfamiliar with a particular community that you are looking at. But you know, okay, let's start here, because as I mentioned before, there is one of my biggest issues here is with the fact that he does not use definitions. And it seems like Chris Bouzy is also like the king of quotations. Like, he has taken that from Chris Farley in his Saturday Night Live sketch from the van down by the river. I'm pretty sure that's the sketch where he uses quotations on like pretty much like every other word in some sketches. But so he's taken that to try to throw shade at all of us, and you know, as if all of us are particularly uppity, right? Like, we are lawyers on YouTube. We are very casual. Most of us don't wear suits, even though, you know, we could. There's a certain advantage to wearing a suit on YouTube. Legal Eagle wears a suit. Lead attorney wears a suit, and they look great. They look fantastic. And that's a good way to, you know, to convey a certain image of what's the word, of, you know, professionalism, so to speak. I think that the rest of us are very intentionally dressing ourselves casually so that we are more approachable. That, after all, if you look at the first video on my channel, that is like the intro video, so to speak, on the channel, the very first one that I ever filmed, and is like, actually, I really should update it, because every time I look at it, I cringe a little bit, because I'm like, oh, this is this is like, I've really come a long way in my overall like video performance and like comfort, and I can feel how uncomfortable I was when I was filming that, and it took way too long to film like a 1.5-minute long video. But anyway, all of that aside, I mean, I think I'm pretty sure I stated in that video that like the whole point of my channel was to make law more approachable, more digestible, more understandable. And so that's why I dress very casually in my set. So like, you know, this whole idea that like we somehow are like very uppity about our presence and the way that we don't take ourselves too seriously. We really don't. You know, we take certain subjects seriously. We take certain standards seriously. And this is why we often will choose the topics that we want to talk about, is because we find them, at least on some level, important, or we know that other people find them important, and we want to do our due diligence for these. So, you know, this idea that we are quote unquote lawyers is very interesting. Now, it also reflects very interestingly, I think, with the fact that the terms of art in the report that he uses don't go defined. You know, like, and a lot of them are terms that could be, that can have multiple interpretations. For example, you know, one of the terms that he uses several times throughout the report is anti-feminist. Now, in order to define anti-feminist, you have to define feminist. And now there are multiple different definitions of feminist depending on who you ask, right? Like, this is not something that is really universally agreed upon by people, because some people will say, you know, a feminist is someone who believes in equality among the genders, or a feminist is somebody who believes in equity between the genders. There could be a difference between those, and it kind of depends on your perspective. So using a specific term without defining how you're using it can make a difference as to whether or not we can fully understand what it is that you are saying and why you're saying that particular content is problematic. We need to be able to analyze these in a way that makes sense and we can all understand that we are seeing the same thing in front of us. Otherwise, if you use generic terms and you never define them, then we can't exactly agree about what it is that we are looking at. Now, I mean, there's also been other stuff that he has gone on. He's really targeted Nate quite a bit here, which is interesting that he got Nate kicked from the platform for about 12 hours or what have you. But, he's got another one where he's talking about, you know, uh Nate talking about cops planting evidence and that kind of thing, which Nate, of course, has responded to provide more context. Now, this is one of the social media. This is one of the things about social media wars, right? Is that we've got people that sorry, excuse me. So Nate has, I'll show you guys. He's got a full context of the video clip that was used. And this is the thing about social media wars that I was just about to say is that anyone can take tiny clips and try to take them out of context. And this seems to be something that Mr. Bouzy likes to do. He likes to take things out of context, not provide context, and then try to fight about the fact that he doesn't need to provide context. I mean, if you're putting yourself out there as a particular expert on these sort of policies for monitoring social media, you really do need to be a fair arbiter. And so this is a big issue. Anyway, let's get some super chats, and then we'll move on to some of the other subjects here that are related here. 2012 Jameson says, "Rip, rest in peace to the Queen. Raise your tea to a great person." All righty. 2012 Jameson says, "Nick is king grifter. Who is the queen?" Ooh, I don't know. It depends on when, maybe, perhaps. I was doing pretty well during the death trial, even though I was doing the same thing that I do anytime. So I don't really know when super chats go up, when super chats go down. I keep my content basically the same, at least my approach to content the same. All right, Jacob, thanks so much for your super chat. Says Bouzy bucks for my girl Lita. Thanks, I appreciate it. Sandra Ramirez says, I personally feel he's going after LawTube subscribers. Also, I've never engaged in anything negative, and yet his website has scored me as disruptive 68%. That's another issue, right? Another issue is how do we know what sort of factors he's using in these reports? I mean, other than specific hashtag campaigns, right? He's got there's certain tweet campaigns for involved with the Deputy Heard case. There's certain tweet campaigns for Meghan Markle, and it seems like those are maybe one factor, maybe all the factors. I'm not really sure. It's not really clear to me, but it is pretty problematic because that's a very narrow scope. When it comes to harassment on social media, it's a much wider scope than just that, right? Because if you can use a particular hashtag, by the way, and also you can use it in a way that is counterintuitive. What do I mean by that? So, someone can jump on a particular hashtag and say, like, this hashtag campaign sucks. Let's use this to promote the opposite message. And you see that all the time. So, but another issue with that is that, you can also be using a particular hashtag and be criticizing someone, and it's not harassment. Like, again, this goes back to this issue of what is the difference between criticism of public figures and targeted harassment? What is the difference between criticism of individuals in general and targeted harassment? Now, we have, when it comes to social media, obviously, if you've been following the channel for a while, you know that there is a difference in the way that courts will treat public figures as opposed to individuals, like private individuals, when it comes to defamation, intentional infliction of emotional distress. And that's because these figures are part of the public conversation. And ironically enough, for Mr. Bouzy, that's because of the fact that we need to allow for public participation in these topics. The First Amendment is really what protects, what creates that distinction between public figures and private individuals. So yeah, there are so many problems with all of this. Ari Jacob also says, I had an opportunity to speak to a journalist, and then you realize he's talking about Taylor Lorenz. Yeah, well, we'll get it. We'll talk about Taylor Lorenz. I know, Ari, you have all kinds of thoughts about Taylor. Anytime I'm talking about Taylor Lorenz, I can usually count on Ari Jacob to be in the chat because she's got. If you guys are unfamiliar, she also has a lawsuit against Taylor, which recently was dismissed without prejudice. So she's got the ability to refile. I think October 5th, if I'm not mistaken, was the order the court gave as a deadline to refile. So it'll be interesting to see what happens with that. But it was another defamation case for basically an article hit job is my understanding of that case. But I think that when that eventually gets refiled, it'll be interesting to take a look at as well. Ari Jacob says, Bot Sentinel has Taylor Lorenz as 2% problematic. That's all you need to know. Right. And if you guys are not familiar with my own brush with Taylor Lorenz, immediately after the Johnny Depp versus Amber Heard trial, Taylor Lorenz came out with an article about the Depp trial that basically said, you know, the people who really won the Depp trial were the creators who covered it, and talked about how all of these people, she kind of went down the list talking about all of these people that pivoted their content to cover the Depp trial, including like K-pop people and all kinds of different content creators that like really spanned a lot of different niches. She mentions me by name, doesn't mention the fact that I'm a lawyer, doesn't mention the name of the channel, which would indicate that law is the topic that I cover. Definitely doesn't mention really anything else, or the fact that I had started covering the case a couple months before the trial started. So, before this became like a massive social media phenomenon. And then said that I had pivoted my content to cover the trial along with all of these other K-pop people and these other individuals. And without the context, without context. And then she also said that she had reached out for comment to me, and that was not true. And when I called her out on Twitter, then they stealth edited and then edited again after disclosing the couple rounds of edits, except that they edited it to be also more inaccurate after the second edit. Like the first edit was fine as to me, but then the second edit was back to inaccurate again, where they said that she had reached out to me through Instagram, even though that was literally the last place that she had reached out to me, all of which were after I had called her out publicly on Twitter. But anyway, so yeah, I definitely agree that is very, very interesting. And the way in which this is all played out here on Bot Sentinel is very interesting. And yeah, anyhow. Well, speaking of Taylor Lorenz, let's go through her article here. Okay, so we've got more to talk about as to misogyny on YouTube and harassment on YouTube and all this kind of stuff. And I'm not going to say that misogyny and harassment don't exist on YouTube. However, do they exist uniquely for women? No, I've seen men get dogged on YouTube as well. Here's the thing, and this all kind of ties into what Mr. Bouzy was saying as well, how he wants to get some massive reforms on Section 230, which, by the way, reforms of Section 230, like the idea that Section 230 should be reformed somehow, is actually a relatively bipartisan issue. Both people on the right and on the left agree that they want it to be reformed. However, they disagree very strongly as to how that should be reformed, right? Because people on the right are saying that they have been targeted by social media platforms, by their algorithms, or by the people that are monitoring the platform, by saying, look, voices on the right are generally speaking being targeted more. We can't freely say the things that we want to say, whereas people on the left are able to run wild with the things that they want to say, and they never run afoul of any sort of issues. Meanwhile, people on the left are talking about, you know, couching it in terms of misinformation, but talking about how they don't want people to be able to say the things that they deem to be harassment. Um, so yeah. Secret mixed squirrel, am I getting fuzzy? It could be. Yeah, I think I might be a little bit. um, it could be my Wi-Fi a bit. So hopefully it'll just kind of come back. All right. Anyway, but the point that I was going to say is that the way in which YouTube polices itself kind of makes sense to me, to be honest. And I say this as a woman on YouTube who has had videos made about me that are good, bad, and indifferent. And sometimes, like, yeah, I mean, like, sometimes very negative. But what happens on YouTube is that somebody makes a video and somebody responds to that video, and then somebody responds to that person responding to that person. This is often how a very long sort of conversation can happen across channels. Oftentimes, what will happen is you have a very big channel that comes out on YouTube. Let's say somebody like Legal Eagle, and he makes a video talking about a particular case. Let's say it's the Kyle Rittenhouse trial, and he talks about what happened during the trial. Why did the jury decide the way that they did? And then if other people that watch the trial disagree with what he said in his video, they can make reply videos that are talking about, no, 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 Legal Eagle got it wrong. Let me tell you why. Let's talk about XYZ, kind of go down the list. This is what happens. This is just an example of within the legal niche, right? But this happens in pretty much every single niche. The most obvious example would be like drama channels, for example. But you can also have um, other channels where anybody is putting themselves out there as any kind of an expert or authority in any sort of way, and that when somebody gets something wrong, or other people think that somebody got something wrong, they make a video talking about how they got something wrong, and that oftentimes generates interest because it seems that it serves the overall purpose of either, I mean, maybe it's guided by Schadenfreude, or maybe it's guided by the fact that viewers really want to have a higher standard of the content that is put out there, whether it is by social media content creators, or whether it's by the mainstream media, by journalists. When people see that they have been either lied to, or that they have been in some respect misinformed, malinformed, they want to see that corrected. They really do. So this is how YouTube tends to police itself, and how YouTube tends to correct itself, is by having these videos. And no one really wants to be the subject of a so and so is misinforming you, right? Because that tends to break down somebody's credibility. So anyway, um, so it breaks down somebody's credibility, and then it breaks down their trust with the viewers as well. So having this one-to-one relationship with viewers and with their ability to provide this information to them, it provides a very sort of healthy relationship in a lot of respects between the content creator and the viewers. But okay, anyway, I've been yammering on. Let's talk about this article. Okay. So here is an article that just came out on September 18th. It says YouTube remains rife with misogyny and harassment, creators say. YouTube creators who sounded the alarm years ago say the company still has a problem. Okay. It says here, in April 2016, YouTube CEO Susan Wojcicki took the stage in front of rows of creators at the company's second ever Creator Summit in Los Angeles. The event was a gathering of some of the internet's biggest stars, and Wojcicki was there to listen to their concerns and feedback. She began by touting YouTube's ad growth and the company's plans to expand its original programming. But when she opened the floor for questions, she was faced with a barrage of criticism from female creators. Women creators weren't doing well, according to an account of the meeting in a new book, Like, Comment, Subscribe, Inside YouTube's Chaotic Rise to World Domination by Bloomberg technology reporter Mark Bergen. Many were dealing with vicious harassment, bullying, and stalking, he recounts. The toxicity on the platform was escalating, they said, and the networked attacks they faced online were growing more threatening. Bergen's book details how one female creator called out the rampant bullying and explained that she was terrified after a fellow YouTuber made hostile videos about her, doxed her, posted her personal information online, and sent waves of angry followers to attack. Another female creator took the mic and said she was dealing with similar issues. I always love when, oh, you know what? How is this not showing up? Sorry, guys. Oh, it's because I was looking at the wrong tab. Sorry, guys. Okay. Here we go. Okay. Alrighty. Okay. Okay. This is something that is very interesting to me, by the way, because, as many people that are familiar with Taylor Lorenz, she famously doxed an account called Libs of TikTok, which is a politically conservative account. And my understanding is, and I don't know this for sure, but I had heard that people were talking about that she had actually shown up to the person who runs that account, shown up to her house to talk to her, and then basically provided all of her public information for the public. And then Taylor Lorenz at some point was doxxed, either before that or after that. I'm not sure. But she's dealt with doxing herself, and she has also doxed other people herself. So it's very interesting that she's talking about this importance of maintaining the standard that people don't dox these women off of social media when she has done that herself to another woman. I'm wondering if maybe the policies that Taylor would be advocating for would be making sure that women content creators are not doxed by men, but maybe it's okay for women to dox them. I'm not sure. Maybe it'll be clear in this article, but perhaps not. I don't know. I will just say that that's a very interesting perspective coming from her, given her history on this particular subject. Ingrid Nielsen, a popular beauty vlogger, I'm a professional, I can do this, was dismayed when Wojcicki offered what she felt was empty sympathy with no commitments to fix the problem, according to Bergen. YouTube just didn't have an answer, Bergen quotes her as saying. They knew the mess was a really big one. In interviews with the Washington Post, creators and experts say that those problems are still an issue, despite updated harassment policies rolled out in 2019. A report issued last month by the Center for Countering Digital Hate, a British nonprofit, declared that harassment against women is flourishing on YouTube. Though the platform recently banned the online men's rights influencer Andrew Tate after he amassed millions in ad revenue, other channels espousing similar ideology are posting regularly and using the platform to grow their audience, the report concluded. Some channels are still uploading Tate's content to YouTube Shorts, YouTube's answer to TikTok. Now, Andrew Tate is a very interesting character. I'm familiar with him. I don't know if you guys watching are familiar with him and with his content. He is, I've seen some of his stuff. And I understand why a lot of people have problems with his content. I also can understand on the other side of the coin why there are people that follow him and that find him to be very, in some respects, refreshing. I'm not saying that I find him particularly refreshing. His content doesn't appeal to me. I mean, I literally am outside his target audience. But it seems that there are men out there, men, probably mostly young men, that feel like they are being, to a certain extent, I don't know if erased is the right term or what have you, but there are men that want to feel like they have a right to be men. And that is maybe a controversial statement to make, but allowing men to be masculine, allowing women to be feminine, um, on its own, I think, is not such a terrible thing. It is when people go to certain particular extremes that you can have toxic masculinity and you can have toxic femininity. Toxic femininity would include, perhaps, if I'm going to throw some shade, doxing women on TikTok. Um, that's the kind of toxicity that we can have on the internet, whether it is from men or from women. Um, so the creation of space for someone like Andrew Tate, I can kind of logically understand where that comes from, and I can also kind of logically understand the appeal that some people have without agreeing that it's appealing, because I don't agree that his content is appealing. But yeah, Shannon Hazel says, I think dismissed is the word you were looking for. Yeah, or maybe emasculated is another one, because I think that there are like I said, there are men who just want to not necessarily like they're looking for permission, but they want to be able to take permission for themselves to be their best selves and who they really should be. Because it's like, underneath, I've seen some of the videos by Andrew Tate, and there's definitely a veneer of what's the like what do I want to say about this? There's definitely, I mean, he definitely plays to the edges, right? So you could call him an edgelord in some respects, because he definitely plays to the edges of, to get attention. And that is, I think, maybe more of a marketing strategy than anything else. But at the same time, I think that underneath the veneer of some of the intensity of his messaging, there are some truths. There are some truths that we could probably kind of parse through and pick out from time to time. But anyhow, let's move on with the article. Alrighty. And also, Ari Jacob says, last thing I'll say about TL, she tweeted, filing a lawsuit, which anyone can do, then doing endless press about it on Tucker and across the right-wing media is meant to cause reputational harm. That is the goal. Seriously? It sounds, yeah, that does. I'm assuming, Ari, I'm assuming she's talking about you there with that statement. And it does sound like she's kind of beating a defamation drumbeat right there, right? Because she's talking about reputational harm, and that's usually, in the context of defamation. But if the statements are made in the context of legal filings, generally speaking, that's going to be pretty protected on through the litigation privilege. But anyway, thanks so much for the super chat, Ari. Anyway, back to the article. Okay. A report issued last month. Did we go over this? Yes, we did. Okay, we talked about Andrew Tate. Okay, misogyny is alive and well on YouTube, the Cyrus report found. Videos pushing misinformation, hate, and outright conspiracies targeting women are often monetized. Wojcicki declined to comment. YouTube spokesman Jack Malin said the platform is dedicated to keeping itself free of harassment. Harassment and cyberbullying are not allowed on YouTube, and we have clear policies that prohibit targeting an individual with threats or prolonged and malicious insults based on attributes like their gender identity and expression, he said. We're committed to rigorously enforcing these policies equally for all creators and encourage any user to flag content they believe violates our community guidelines. But in interviews with The Post, 7 creators detailed how misogynist creators mobilize their audiences to attack certain women creators. If a woman creator goes viral, they said, she will undoubtedly be subject to a waterfall of hateful comments. Posting on YouTube as a female creator can feel like walking across a minefield, the influencers told The Post. Okay, so I have had the wonderful privilege of having a number of videos actually land on the trending page, which is amazing. This was during the DEP trial. Some of my recaps went viral, as well as my main like primer video for like what is this case about. Those actually did end up on the trending page, so they did go viral. I did not experience that from people in response to those videos going viral. I definitely didn't, which if I were in a conversation with Taylor Lorenz right now, I would imagine that her her retort would probably be something along the lines that, oh, well, that's because you were dunking on another woman. And so therefore, it still fits in the misogyny category. Meanwhile, I was not. I was talking about very specific legal elements, facts that support or don't support certain things, and giving recaps on literally what happened. So I don't think that can possibly fit into that box of misogyny. And the fact that I didn't experience any of that. Have I experienced drama on this channel? Yes. Have I been a target of drama on this channel? Yes, I have. Is that because I was a woman? No, it's because there were certain things that happened. There were miscommunications that were made, and a lot of people were just exhausted and very emotionally amped up. And things happen, mistakes were made, right? And the best thing that you can do in those circumstances, I have found, is to back away. Don't add content to the fire. And maybe get some sleep and deal with things with a clear head, so that you can kind of strategize a little bit better and maybe make decisions like you normally would under normal circumstances. But do I think that I was targeted because I was a woman? No, I don't think so. People can have their opinions about me for all kinds of different reasons. And maybe there are people that don't like me because I'm a woman and because I've reached a certain level of growth on my channel. I don't know. It's not my business to figure out why people like me or don't like me. But yeah, it's not, none of that is because of the fact that I am a woman. Is that to say that doesn't exist on the platform? Probably not. That's just not been my experience. And God bless, I've had some nice growth on this channel. Okay, let's get back to this article. Okay, so I mean, if a woman creator goes viral, they said she will undoubtedly be subject to a waterfall of hateful comments. I disagree with that, because that's a pretty blanket assertion. And maybe this is women creators, female creators, that are saying this based on their own experiences. Sure, they can have that perspective based on their experiences. It has not been mine, so I definitely refute that as a blanket statement. YouTube will turn a blind eye to anything that brings a lot of viewers to the platform, said Adelina Sabrina Rios, a political comedy YouTuber in Los Angeles. They're aware that people on their platform will blatantly spew sexist and misogynistic stuff, and it becomes a breeding ground, and they're totally okay with it because they bring in lots of viewers. I mean, here's another thing. We have also seen on this channel, arguably, sexist comments that are I mean, not misogynist, but the inverse, right? We've got a lot of, I mean, how many women love the hashtag Wood Daddy Stack. Our buddy Rob over at Lawn Lumber. I mean, he deals with some nice dirty comments on his end fairly regularly, and he handles it nicely. He handles it like a champ. Um, he and Mike, Law Talk with Mike, they both were the subject of some really funny super chats that were flying at one point during the Deputy Heard trial, that were just directed at them. I mean, we basically could have started a whole dating show for those two guys with some lucky subscribers, some lucky viewers, right? We could have auctioned off some dates. I could have made a lot of money auctioning off a date or two with those guys. That would have been hilarious. But I'm not going to obviously advocate for that without their permission. But that exists on this platform too. There's nothing about that in this article. It looks like, I mean, unless there's something that I haven't yet read, but I doubt that it's going to be there. So the ability to make comments about the opposite sex, they're there on both sides. Does Taylor Lorenz have a problem with the hashtag Would Daddy Stack? I would like to know that. Maybe she does. Maybe she would say, yeah, that's a problem too. In which case, to the extent that Rob has embraced that, I would say, look, everyone is having fun with this. If no one has a problem with it, no one has a problem with it. But maybe that's ultimately her point, is to say that women that do actually have a problem with it don't want to be the subject of it. I suppose. But then again, when I've been on Nick Rekieta's channel and I get people commenting about how they want to see my feet, it's all in good fun. So anyway, let's continue with the article. Arto Rissanen says, I was fawning on Mike just for the giggles too. I didn't want there to be those messages only from women. I am for equality. Hey, you do you, Arto. Oh, that's awesome. So, okay. Creators said that the Amber Heard versus Johnny Depp defamation trial was a pivotal moment in the online harassment landscape, emboldening misogynistic YouTubers and allowing them to collectively amass millions of followers. Well, for one thing, here's a typo here. It is the Johnny Depp versus Amber Heard defamation trial. Maybe that is a distinction without a difference, but he was the plaintiff in that particular case. She was a counter plaintiff. But I think it definitely indicates her perspective on that trial if she thinks that Amber Heard was the plaintiff. Okay, so saying it was emboldening misogynistic YouTubers and allowing them to collectively amass millions of followers. Depp won his lawsuit against Heard. Creators said the trial and the verdict normalized a level of hate that has become commonplace on the platform. I don't know about you guys. I have not seen commonplace hate on the platform. I have seen plenty of people criticizing Amber Heard, which you have to then take a look at, why are people criticizing Amber Heard? Are they criticizing Amber Heard because she is a woman? Or are they criticizing Amber Heard because she made false statements about Johnny Depp? That she continues to make false statements about Johnny Depp, even in the face of losing a trial and having a jury tell her that she lost. We also have the ability to criticize our public figures, regardless of whether they are women or fit into any sort of minority or marginalized group, any sort of category like that. If a human being, regardless of whether that human being is a woman or falls into a racial category, religious category, gender category, sexual orientation category, regardless of all of those things, we should have the ability to comment on and critique the decisions that these public figures make, because they have the ability to impact society at large. So by implying, even just by implying that criticism about this individual is just targeted harassment of a woman, without doing any sort of digging as to what the content is that people are actually saying about this individual, what it is, what the problem is. Like, what is the problem that they have with this individual? That's a big problem, right? Because you're just trying to bolster someone and keep them from being accountable for their actions. Big problems there. Some very big problems. And emboldening misogynistic YouTubers and allowing them to collectively amass millions of followers. Is this individual accounts that each have amassed millions of followers because of this, or is this collectively millions of followers have been amassed across multiple platforms because of um, uh, misogynistic rhetoric? At the same time, are you saying, like, how are you defining misogynistic? Are you saying that somebody's misogynistic just because they are criticizing a woman? Or are you saying that they are misogynistic because they are specifically targeting the aspects of her that make her a woman and using that to take her down? There's a big difference there. I was getting called Amber Heard a lot during the trial, said Rios. I had people tell me they wish I died. It's constant. I'm always adding new filters to my comments because that's the only thing I can do. Now, I will always say that threats of violence, threats of any kind of violence against an individual, regardless of whether I vehemently disagree with the things that they have done, I will always say that I don't agree with that at all, and I never want any viewers of any of my videos to take any criticism to mean that they should go and slide into their DMs with death threats, other threats of violence, other kinds of threats against family members. None of that is okay. Um, but at the same time, they also she doesn't Lorenz doesn't give any sort of context here as to like what is like what's going like what's happening here. Like why were people jumping onto Rios? Did was there some sort of drama there? Was there some sort of controversy to the point that people were calling her Amber Heard? Did she make some kind of an accusation against somebody that was false? If she did things that were very similar to Amber Heard that were provable and that people actually had evidence for, that's one thing. But if people were just taking the fact that they don't like her and then therefore calling her an Amber Heard, then that's, I guess, another thing. But even then, calling somebody an Amber Heard, that's just a BS comment from somebody who, if you're a creator, you're going to get people that hate you. Like, regardless of how nice of a person you try to be, that you want to be, you're gonna get people that hate you. And this is regardless of men or women. So I have a problem with the fact that there's no context for that interaction. Creators who leaned hard into anti-Amber Heard content saw their followings skyrocket through posting videos that experts say are misogynistic, amassing money from merchandise sales and ad revenue in the process. Matthew Lewis, a YouTuber in Tennessee known online as That Umbrella Guy, has grown his following to more than 400,000 subscribers, largely by posting anti-Amber Heard content. Depp's lawyer said he'd been in communication with several YouTubers, including Lewis. YouTube channels like That Umbrella Guy are not an exception to the rule. They are the rule, said Christopher Bouzy, founder and CEO of Bot Sentinel, a research firm specializing in disinformation. YouTube is telling women it's okay for men to publish and monetize videos insulting and demeaning women. That Umbrella Guy's YouTube videos have received over 116 million views, and YouTube has refused to take action. Insulting and demeaning a person is, yeah, okay. So you don't like that. The First Amendment allows for that, though. It does. And regardless of whether these are on platforms, people are going to talk crap about creators, men or women. I know this from my own experience, and I've seen other people see this on their own. It is interesting. It is interesting that Christopher Bouzy is quoted here in this. seeing as he did take, some moves that many would see as targeted harassment against Nate the lawyer, talking about Nate's upbringing, talking about the fact that Nate grew up with two parents that had drug addictions, most notably crack, and then using that to basically demean him and try to take him down a peg. So it's very interesting that Christopher Bouzy is quoted in this article, and of course that he's trying to posture himself to try to be an authority in this space. Very, very interesting. um, but but the fact of mentioning that umbrella guy, talking about how he's posting anti-Amber Heard content, that doesn't make him a misogynist. If that is the basis upon which Taylor Lorenz is claiming that umbrella guy is making misogynist content, that's not enough, in my opinion. Because if you are criticizing a woman, look, as a woman who is putting my face out there, I want to be held to the same standards as men. I don't want people to hold back as to their analysis of my credibility in comparison to other creators that are men, because that just implies that they think that I can't handle it. So I want to be held to the same standards, regardless of whether that is, me being paid the same amount as men for the same kind of work, or also being subject to the same kind of criticism. Because when somebody puts you through the ringer, it shows that they respect you. They respect your voice. They respect the fact that you have a following. They respect the fact that, even if they put it in terms that are maybe a bit more spicy, a bit more rude, and they, along those lines. When somebody goes down the route of taking the time to criticize you, all it does is it shows that they care about the things that you say. So when someone omits women from their criticisms on these subjects, all that does is says that their voices don't matter, in my opinion. That may be an unpopular opinion, especially among folks like Taylor Lorenz, but I very much stand by that. I don't know. Let me know, you guys. I mean, what do you guys think? Do you think that do you agree with that people can that criticism of someone kind of indicates that person cares about what that person says? Or do you think that or I don't know, do you think something else, that there might be another reason why somebody is going through the process of criticizing another person? David Battler says TL receives criticism, not harassment. Let a court decide. LOL. Yeah, I mean there is a difference, right? There's a difference between criticism and harassment. Bailey Allison Dubs, I agree with you, Alita. Mary Vasquez, 100% agree. Love Living Peach Dream says, no, they could just be an ass. That's true. That's true too. There's also that. Techian says, it depends on how the criticism is made, IMO. That's fair. That's also fair. Okay, so back to this quote. YouTube is telling women it's okay for men to publish and monetize videos insulting and demeaning women. That umbrella guy's YouTube videos have received over 116 million views, and YouTube has refused to take action. That's because they're not problematic. He's criticizing someone. He's criticizing someone who happens to be a woman. There's nothing wrong with that. I mean, granted, I have not seen every single one of Tug's videos, so I can't vouch for all of the content. But from the videos that I have seen, he's going through filings. He's going through evidence that has come out, and he's talking about how the things that she said in her op-ed were bogus and how Johnny Depp was right. And guess what? A jury agreed with him. Lewis did not respond directly to a request for comment. He later published a video saying that in years past, he had not exclusively posted Amber Heard related content, but that he had published content about comics. In a tweet after the post sent him questions, he acknowledged his role as a leader of Comicsgate, a campaign beginning in 2018 that opposed diversity in the comic book world. I don't know what this is all about, Comicsgate. this is a characterization of something, of an event that happened, or an incident, I guess, that happened. Comicsgate. It sounds like the posturing from Taylor Lorenz is that that was something that was in. I mean, it's intended to keep women out, I guess. There's some sort of a misogynistic bent to what happened at Comicsgate. And but I that's one person's interpretation. I would very much like to see a um a characterization by somebody who is not Taylor Lorenz, to see like what was Comicsgate? What was it really? Were there ways in which it went sideways? Was there, you know, what does this mean that he acknowledged his role as a leader of Comicsgate? Does that mean that he was just somebody who was commenting on it and a lot of people were paying attention to what he was saying? That doesn't necessarily mean that he was the worst of the voices, um, calling for misogyny. If I mean, this is like I'm kind of like making some assumptions that I'm basing that off of. So if those assumptions are incorrect, then that's, I'm just sort of riffing here, right? I'm not supposing that that's actually what happened. But like you can be a sort of leader of Comicsgate and not say things that are particularly problematic, I suppose. Like I can at least imagine that this is coming from someone who is unfamiliar with what that was. But again, like just kind of referring to something without defining it, without really explaining it, without giving context to it. This is something that Taylor seems to be particularly good at. Many of Lewis's earlier titles include attacks on quote unquote social justice warriors and quote unquote woke culture, such as SJW's Ruined Comics. Comic Industry 2019 numbers reveal there's no coming back from wokeness, and SJWs never learn. SJWs take wrong lesson from study, hilariously missing they're the bad guys. High-profile women who speak up about sexism or who are perceived as too progressive are frequent targets of misogynistic YouTubers. Earlier this year, after public outcry and a report by Bot Sentinel, YouTube began de-ranking anti-Meghan Markle channels and videos dedicated to misogynistic commentary on Markle, who has been the subject of much negative discussion in the British press as well as on the web since she married Prince Harry. Again, misogynistic commentary, how are you defining that? Does that mean negative discussion? If you're saying that she's the focus of negative discussion, that's not the same thing as misogyny. And also, what do you mean by high profile women who speak up about sexism or who are perceived as too progressive are frequent targets of misogynistic YouTubers? Like what is the criticism that they are facing? What's the specific context? We've got to go one by one and look at these. You can't just draw an impressionistic paintbrush on these topics and then just expect us to just accept what you are saying. Women creators say they're frustrated that YouTube hasn't done more. They say the company dismisses harassment and hate campaigns as quote unquote drama. YouTube turns a blind eye when some of their larger creators spew misogyny, Rio said. So people in their comments really take hold of that messaging and go out and harass female creators, or they inspire smaller creators and those smaller creators go on to harass women and the cycle continues. Now, I mean, I will say that there is a certain cycle of toxicity that can happen, right? Because, people have these parasocial relationships with a lot of creators. And, when somebody goes in and has a very emotional appeal to their viewers, they can definitely incite viewers. I mean, sometimes viewers like drama. Human beings like drama. That's a lot of the appeal. I think that a lot of people have in a lot of the legal content here is because there's a lot of drama involved in these, right? There's drama and litigation is all drama. That's what it is, right? There's a controversy. There's literally a controversy that is being played out in the courts. So people do like drama. And so, there are certain cycles of toxicity that can happen. And we actually ironically saw that played out by Bouzy's followers. I saw it in my replies and my mentions. I saw it in, people attacking boss attorney Bree and Nate the lawyer. Not Nate the lawyer, but also Natalie Lawyer Chick. That's what I meant to say, not Nate the lawyer. But Natalie Lawyer Chick and boss attorney Bree. And unfortunately they kind of got dogged in that. And they really didn't have anything to do with what we were talking about. Natalie like she didn't even really know what was happening because she's been focused on a trial that she's got this week. Um, but anyhow, I this does exist. This does happen. It's not unique to female creators. Olivia D'Andrea, a wellness and self-improvement YouTube star in Los Angeles with over 2.3 million followers, echoed those frustrations. Some commentary channels where YouTubers give their opinion or analysis on a variety of topics are particularly troubling, she said. Commentary YouTube channels, especially the fitness ones, will comment on my videos and react and analyze what exactly was wrong with me, she said. The critiques of her body are hurtful, she says. She's a wellness and self-improvement YouTube star. That is your area of expertise or area of authority. People are going to nitpick that area if they think that they have a problem with it. So, at the same time, when someone puts themselves out there in a particular niche, you have to be prepared for criticism that falls in line with that niche. People can criticize my legal reasoning on all kinds of subjects, and does it bother me? I don't know. Sometimes, maybe. Sometimes some comments I'll read and I'm like, ugh, that really sucks. That's a little bit of a punch to the gut. But then others, I'm just like, who cares? You learn to build a thick skin. And again, those comments that I've received having to do with like my legal reasoning or how I talk about law have nothing to do with me being a woman. Generally speaking, is that 100% of them? Probably not. But is that the overwhelming majority? No. Is that something that I feel like I am dealing with on a daily basis? No. So, I understand women not wanting to have people comment on their bodies, right? Because, yeah, I don't like people commenting on my body either. But that's also why I dress the way that I do. That's why I usually don't make my body a focus of content, because then you, in a certain respect, give permission to people to comment on it. And when you put yourself in a specific niche that has to do with wellness and self improvement, obviously that can go too far. But if somebody is just saying any sort of criticism about my body or about my physique I don't like, eh, I don't know that is a legitimate criticism of the platform itself. Taupe says this Olivia did some this is how I lost weight and people are reacting to that saying it's unhealthy. That also I mean, if that's the case, if that's a specific context, this is then that would be once again context that is very important to know. So if that's the case, Taylor Lorenz, why did you leave that context out? Because it doesn't fit the narrative. I don't like that. I don't like that. And you know what that does? Every time I read a Taylor Lorenz article, I have now gotten into the habit of looking to see where she's taken things out of context, because she tends to do that in ways that she is not exactly clear on. So, and obviously I'm taking Topes at their word. So this is I'm not, for the purposes of this specific commentary, I'm saying if that is true, then that's a big problem for this article. I don't know for a fact that it is true, but that would be very important to know if it is. People in D'Andrea's comment section became emboldened by these videos. D'Andrea said that YouTube commenters once used a screenshot of her feet on an airplane to figure out what airline she was flying on what date, then used that information to locate her school and called the school to get her class schedule. I do sometimes fear, I hope no one finds out where I live, she said. Okay, now that is scary. That is scary. That is definitely going beyond, going a bit beyond commentary on the content. Um, So, people that put themselves out there for their content also are entitled to a certain level of privacy if they try to maintain that privacy. For example, I try not to talk about my family life too much, and that's for good reason. It's because I want to maintain some healthy boundaries, and I want to protect the privacy of those that I love, who also want to have some level of privacy. So I don't like people, trying to figure out somebody's class schedule, trying to figure out where they live. If they don't want to be found like that, not a big fan of that either. Akila Hughes started making videos on YouTube in 2007, but quit the platform partially, she said, because of the racist and misogynistic attacks she endured. She attended the meetings with Wojcicki in 2016 and is dismayed by the platform's lack of progress. Hughes and other creators said that YouTube could do several things to make it a safer platform for women, such as adding more robust controls to the comment section, banning certain bad actors and those whose channels are dedicated solely to attacking specific women, downranking misogynistic content, and providing more resources for female YouTubers suffering from online harassment. I don't need any specific resources that aren't available to men. I don't need that. I think that there are tools, there are resources on the platform to maintain the comment section. You can ban certain terms and phrases, and it's pretty unlimited as to how many terms and phrases you want to ban, to prevent certain comments from showing up. You can also have certain filters in place so that comments that appear to be hateful or appear to be problematic in some sense or another, that they don't show up unless you actually actively approve them. So that is available to men and women across the platform. I mean, that for me personally has been pretty good so far. Even when I've been, a central figure in all kinds of commentary videos that were not exactly, the most fun videos to be a subject of. You know, I got all kinds of comments in my comment section, and there are ways to try to mitigate those, both in a chat in the live stream and in the actual comments on replays and on regular videos. So I don't know what exactly they're talking about in terms of like what sort of tools they want for women to be able to have access to that men then wouldn't. I don't know. I mean, I don't, unless they give some concrete examples, I don't see any reason to provide those. The fact that success on YouTube for women is not the same as it is for men, she said. It's a target on your back the moment you become successful on YouTube as a woman. YouTube wants you to post all the time. They want you to find success, but they're not going to protect you once you have it. And this is the other side of being a public figure. That I think that this is one of the things that I think that some social media, content creators, it's like this new space where people can become public figures in a very short amount of time. There's the traditional ways of being in the music industry, being in Hollywood, being on TV shows, being a model, these kind of ways that we can all sort of like be like, oh, this person is now a public figure. Like I understand because this is somebody that's in a movie that is being broadcast all across the country or across the world. You know what I mean? Like, so like we can traditionally see those people as public figures, but I think that maybe some of these people that have been interviewed here maybe don't realize um to what extent they themselves have become public figures by putting themselves out there on the platform in that respect. And so once you become a big YouTube channel, a big TikTok channel, a big Instagram account, you become a public figure, whether you are a man or a woman. And our First Amendment rights allow for criticism of those individuals, very robust criticism, that sometimes that can feel like targeted harassment. You can have whole channels dedicated to criticizing a particular individual or talking about a particular legal issue. There are accounts that are dedicated to the Marilyn Manson litigation that is, a whole cluster of cases, that because that is what they are most interested in. And what they will tell you is that they are interested in getting to the truth, not in harassing one side or the other, but rather in getting to the truth. And so that is just what they want to focus on, is that particular case or individual or what have you. Ronnie G says, there are hundreds of call out channels. If a creator is problematic, there will be commentary. YouTube communities police themselves. Exactly. Exactly. Sassy Living says, once you create a job that is all about being watched / listened to on a social media platform, then you open yourself up to public criticisms. I totally agree. Now, Steffi JPG says, thanks so much for your super chat. Says, I don't know how you can say I don't agree, but I see his point. Girl, he was pro abuse against women. So I haven't seen any videos, and I'm assuming you're talking about Andrew Tate there. I have not seen any videos talking about where he's talking about abusing women. Obviously, if that is the case, I have an issue with that. I don't like violence of any kind against any individual, whether it is against a man or a woman, whether it is DV or otherwise. What I was saying is that I can understand some of the appeal to an individual like him because he is so different from a lot of the messaging that men will often get in this on social media or in the legacy media, corporate media, what have you. So that is not to say that I agree with him. There's a lot of stuff that he has said that I just disagree with. But I can also understand some of the root points that he's getting at when he says things that are particularly bombastic and that are particularly offensive, which I don't like the offensiveness of those messaging. But there are some things where I'm like, he's being very, very rude about women, and I don't like the way that he is indicating a certain cheapness to women, I guess, in some respects. But I can also understand where he's talking about that men have to value themselves. There's things like that. But yeah, that is on that. Thanks so much for the super chat. So, okay, that is Taylor Lorenz. I mean, it is interesting. She's also talked about other stuff recently about MSNBC's Morgan Radford over harassment. She criticized MSNBC's Morgan Radford for her comments on harassment of Taylor Lorenz because she was the subject of some she says that she was the subject of harassment on the internet. Whether that is harassment, whether that is criticism, I guess is up to interpretation, I suppose. But here is basically what she said here. And let me see if I can, okay. This is a New York Post article here. Okay, let me just read this real quick and then we'll move on. Taylor Lorenz lashed out at MSNBC correspondent Morgan Radford for quote unquote mishandling a segment from earlier this year in which the Washington Post internet reporter broke down in tears while describing abuse and harassment she has received from critics online. And abuse and harassment are in quotations here. No bigger regret in my career than making the mistake of thinking Morgan Radford knew how to accurately report on abuse and harassment, Lorenz tweeted on Tuesday. Her complete mishandling of the story has led to immense fallout and months of abuse. I cannot warn women loudly enough to stay away from her / MSNBC. Lorenz added she produced an insane garbage segment months ago that misgendered a colleague, then refused to immediately correct it, lied about my harassment campaign, completely misrepresented what I said and how I've handled 2 straight years of relentless abuse. Never apologized or fixed it. Completely misrepresented what I said and how I've handled 2 straight years of relentless abuse. Never apologized or fixed it. This is very interesting to hear. I mean, this was just maybe about a week ago that this article came out. It was responding to some. It's in response to some tweets that she put out. Interesting how the shoe was on the other foot. um, so misrepresenting things in articles, not correcting it, not apologizing for it. Interesting. Interesting coming from someone like Taylor Lorenz. Lorenz went on to accuse Radford of throwing a colleague under the bus, especially when it purports to advocate for the marginalized communities. Also, interesting. Advocating for women much. Interesting. She says, it is a reminder that cable news will always, above all else, exploit people for cheap views, Lorenz tweeted. They fundamentally do not care. Lorenz urged women journalists to not trust anyone in the media to tell your story or report on harassment accurately, especially TV news people. I think that the same can probably go for people who put themselves out there as journalists for the Washington Post. This definitely sounds like some what Viva Frei would call confession through projection. It was very interesting to see this kind of pop up when I was researching and trying to find the article that I just went through that was actually written by Taylor Lorenz, because this definitely feels like, I mean, it's like it reminds me of Mean Girls, as often these kinds of articles do. When the principal says, asks all of the junior the girls that are in the junior class, the high school, when they're having like a full school meeting after they've all just been physically tearing each other apart over the burn book that was made public by Regina George, and then and Regina George raises her hand and says, I'm sorry, but some of us here are just a victim and have absolutely nothing to learn here, and so really shouldn't even be here. And then the principal turns to the room and says, yeah, that's a good point. Raise your hand if you've been personally victimized by Regina George. And like literally everyone in the room raises their hand. This is how this feels to me. having been on the receiving end of of misinformation being published in a journal that is supposed to be as trusted as the Washington Post, where literally their tagline is "Democracy dies in darkness," and yet they've got stealth edits, they've got misquotations, they've got misrepresentations all up and down the place, things taken out of context, all kinds of issues, and particularly with Miss Lorenz's writings. So that's what I've got to say about that. I thought that was particularly interesting. I don't know about you guys if you feel the same way, but let's talk about the next topic. We've got, let me see here. Okay, let's talk about Adnan Syed. This has been a very, very interesting interesting development here. I don't know if you guys are familiar. Let me know in the chat or in the comments below if you're watching on the replay, if you are familiar with the case of Adnan Syed. And if you are, you probably learned about it from the podcast Serial. Pulling up an article here, which was a podcast that was started in 2014 by investigative journalists. So speaking of journalists that are doing a good job doing investigative journalism. Now, I know that folks have talked about, there's another podcast that followed that up. It was run by 3 lawyers. There was like information that they say that Sarah Koenig actually didn't even dig into. I don't know if they were, if it was a critique of Sarah Koenig's work, or if they were just sort of adding more to sort of flesh out even more. But I remember being completely captivated by this podcast, and I haven't really followed too many true crime podcasts and TV shows and stuff like that, but this was one that really, really got me. And when I was first tweeting about this, I thought that it was like at some point during law school, but it was like just after I got out of law school, and I think I was like either I had just taken the bar exam. I can't remember exactly, but it was somewhere right around that time. And and it was such a captivating podcast. She had a really great way of storytelling the what happened between the two individuals, the young girl, she was a senior in high school, who was murdered by someone, and then the young man um, who was implicated in that murder, and then eventually investigated, put on trial, and convicted. So she goes into the story of Adnan Syed and Hae Min Lee. So Hae Min Lee was a Korean American teenager. She was in a romantic relationship. She was dating Adnan Syed, and they were, I guess, in this relationship, and she went missing in somewhere outside of Baltimore in Maryland, and they found her remains. Then he was suspect number one. They never looked past him, from what it looks like. And there were all kinds of evidentiary issues with that investigation, with that trial. And so he had people that were advocating for him for years. This was in 1999 that he was convicted, as a senior in high school, convicted of murder. Then he had people that were advocating for him for years. They tried getting the verdict overturned in so many different ways. They tried appealing. There's a whole list of things that they tried doing. Then somebody got the attention of Sarah Koenig, and she had this podcast, and it was I guess it was sponsored by MailChimp. And if you guys, let me know if you watched this podcast or listened to this podcast, and if you remember the ads for MailChimp, and if as a result of listening to the podcast, you can no longer hear MailChimp the same way, that like there's a part of you that feels like you have to say MailChimp, because in the ads for every single episode towards the beginning. Yeah, exactly. So they were running this ad mention. That's just like a normal ad mention, and it was like somebody that was going up to random people on the street that was like, "Hey, yeah, this is brought to you by MailChimp." And they would have so many different people saying MailChimp, 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 and then like the last person, it's like some woman that's like MailChimp, like she didn't understand, she didn't know how to, she didn't know, like she was having a trouble pronouncing it. And it was like the Kimp with like a question at the end, like, is that how I say it? That like every single time, as a result, I personally could not say MailChimp for a very long time. Even after like having MailChimp as a service myself, I was always like, it's MailChimp. Anyway, totally random aside, but yeah. So this podcast went completely bananas, and as a result, there was new interest in the case. And so in, I think, 2019 was when they filed a new appeal, or there was a, sorry, excuse me for a second. I'm getting ahead of myself here. So on September 19th, that's today. So prosecutors from Baltimore investigated Syed's case, declaring that new evidence they uncovered undermined Syed's conviction. They filed a motion on September 15th, 2022, to vacate his conviction, citing Brady violations from prosecutors who worked on the case decades ago. On September 19th, Circuit Court Judge Melissa Finn vacated Syed's conviction. He was released from prison the same day. So on I mean, just like literally less than a week ago, the state filed a motion to vacate his conviction because they realized that there was certain evidence that was not provided to the defense. Now, this is a very, very hard and fast rule. So, we've talked about professional responsibility on this channel before. Lawyers have certain very strict rules that we have to abide by. And prosecutors actually have extra rules on top of that because they are acting with the full force of the state behind them. So they have extra restrictions that they have to meet. When it comes to criminal cases by prosecutors, if there is any evidence that they come across that is potentially exculpatory, in other words, it's evidence that could lead to the defendant's acquittal, then they have to provide that to the defense. They have to. That's called a Brady violation if they don't. And that's a very, very serious offense. That is something that would implicates some very serious professional responsibility issues. And that's because prosecutors are supposed to be in the business of justice, not convictions. So let's talk about this latest article here. Here's an article from the BBC. I was trying to find the one that I had posted elsewhere from AP News, but it's going to be basically the same. It says Adnan Syed, conviction overturned in serial podcast murder case. A U.S. judge has quashed a Baltimore man's murder conviction in a case that spawned hit true crime podcast Serial. Adnan Syed was 18 when he was sentenced to life in prison for the death of his ex-girlfriend, Hae Min Lee, whose body was found buried in the woods in 1999. Prosecutors last week asked the court to throw out his conviction, saying a year-long case review had turned up 2 alternative subjects. Mr. Syed will be released into home detention. The 41-year-old's shackles were taken off in court on Monday after he spent nearly 23 years behind bars. That means more than half of his life has been spent behind bars. If you are someone that believes that he was wrongfully convicted, that is an absolute outrage. Baltimore Circuit Judge Melissa Finn said she was vacating his conviction in the interest of fairness and justice, adding the state had failed to share evidence that could have helped his defense at trial. The decision does not mean he is innocent. Judge Finn has ordered a new trial. A jury found Mr. Syed guilty in 2000 of premeditated murder, kidnapping, robbery, and false imprisonment. Now, actually, I don't think that this is fully accurate because what I was reading earlier is that the judge gave the state 30 days to either dismiss the case or to file for a new trial. Now, I will say, while I mentioned that before I continue on, if there is a new trial, I would imagine that Court TV and Law and Crime are going to want to be in there because there's a lot of interest in that trial. In which case, if it is televised, I'm 100% going to be live streaming it on this channel because I am very interested. Like I said, I was captivated, just like so many other people were, by this particular podcast, by this story. I know that a lot of people that were paying attention to this case were very interested specifically in whether or not he did it, whether he did or didn't do it. And I remember, as somebody who had just finished law school not too long before this, I was less captivated by those questions and more about the growing certainty that due process had not been followed in that particular case and that he was wrongfully convicted. Whether he is innocent or guilty, it remains to be seen, I suppose. But I know that there are plenty of people that disagree with that statement. I know that there are people that vehemently believe that he is absolutely 100% innocent. That has not been fully played out in a court of law because that's not the decision that the court made here. But I think that if he were to be put on trial again, there's a very good chance that he would be exonerated through that trial. A jury found Mr. Syed guilty in 2000 of premeditated murder, kidnapping, robbery, and false imprisonment. Prosecutors argued he was a scorned lover who had strangled Miss Lee, his classmate at Woodlawn High School, and, with the help of a friend, hid her body in Baltimore's Leakin Park. They relied in part on mobile phone location data that has since been proven unreliable. This is talking about junk science. We've talked about junk science on this channel. Every appeal Mr. Syed filed over the past 2 decades was denied, including his most recent attempt in 2019. It was the 2014 podcast Serial that focused worldwide attention on the case and cast doubt on Mr. Syed's guilt. Episodes of the show have been downloaded more than 340 million times. The case has also spawned other works, including an HBO docuseries in 2019. The Baltimore State Attorney's Office, which studied the case over the past year alongside Mr. Syed's latest defense attorney, said on Wednesday that he deserved a new trial. Prosecutors said they lacked confidence in the integrity of the conviction and had identified two new potential suspects who were known to the police since the 1999 murder. More leads. Were they followed? To what extent were they followed? That would be interesting stuff for a new defense attorney to bring up. Fart Knocker also says, and if he's found guilty, it depends on what kind of evidence gets submitted at trial, what kind of evidence is kept out, what kind of evidence is admitted, and what gets put in front of the jury and how. So, I mean, I wouldn't say that I would immediately determine that a guilty verdict means that justice has not prevailed in that particular case without seeing how that actually plays out. And that's part of the reason why I would very much like to live stream that trial if it happens. Neither suspect has been named, but officials said both had documented records of violence towards women, including convictions that occurred after Mr. Syed's trial. One suspect was cleared from the investigation into Miss Lee's death after failing a lie detector test, a method no longer admissible in many U.S. courts. Yep, we've talked about lie detector tests. We've talked about that. Again, junk science. It seems like there was just like so much junk science in this particular case. Our prosecutors have been sworn to not only aggressively advocate on behalf of victims of crime, but when the evidence exists, to exonerate those that have been falsely accused and convicted, lead prosecutor Marilyn Manson said outside the court. She was interrupted by loud cheers as Mr. Syed exited the building through a scrum of cameras and supporters. Before the ruling, the victim's brother told the court through tears that he was not against the investigation, but had been blindsided by prosecutors. Every day when I think it's over or it's ended, it always comes back. It's killing me, said young Lee. And that I have a lot of empathy for as well, because you have a family here. You have a family here that is trying over decades to move on with their life, to get closure. Whether or not they found some level of closure through that particular trial, thinking that they found some closure, only to have it opened up in so many different ways. I have a lot of empathy, because at the end of the day, yes, justice for defendants that are wrongly convicted is a very strong and good thing to pursue. But we also need to keep in mind that at the end of the day, one of the most important things here is also justice for these victims. And I really feel for the family, especially if they've been blindsided by this. This is not a podcast for me. This is real life, a never-ending nightmare for 20 plus years. Steve Kelly, a victims' rights lawyer for the family, said the Lees had been shut out of the legal process and were deeply disappointed with the way they had been treated. All they wanted was information, said Mr. Kelly. If the truth is that somebody else killed their daughter, they want to know that more than anyone. Now, that's unfortunate too. What triggered the latest case review? Serial Productions, which produced the podcast, has just released a new episode, the 13th, about the latest in the trial saga. It reports that last year, Mr. Syed's legal team applied for a review of his sentence under a new Maryland law, which applies to those given more than 20 years in prison for crimes committed when they were under 18. Mr. Syed was 17 at the time of the murder. As part of his sentence, an official in Baltimore City's state attorney's office examined the case files and found 2 handwritten notes relating to information phoned in about a potential alternative suspect, the podcast reports. It was these notes that were not shared with the defense team in violation of legal protocol, it says. Not just legal protocol, but constitutional rights. The Impact of True Crime podcast. Serial brought international attention to the murder of Hae-Min Lee and was one of the first hit podcasts of the past decade's boom in audio content. It was followed by other shows which raised questions about existing murder convictions or drew attention to cold cases, attracting big audience and also possibly having an impact on the course of justice. They include In the Dark, a U.S. podcast focusing on the case of Curtis Flowers, a Black Mississippi man tried 6 times for the same crime by the same white prosecutor. His conviction was subsequently quashed by the U.S. Supreme Court over racial bias, and he was released after 23 years in prison in 2019. The unsolved killing of Alastair Wilson, a father of 2 who was shot on his doorstep in the seaside town of Nairn in the Scottish Highlands in 2004. I'll also apologize if I'm mispronouncing the town of Nairn. Maybe Secret Miss Squirrel can let me know if she's in the chat still, if I'm mispronouncing that. It was the focus of BBC's podcast, The Doorstep Murder, which came out in 2018. His death remains unsolved, but Police Scotland's major investigations team said earlier this year they have a planning dispute was the likely motive. They believe a planning dispute was likely the motive. A popular crime podcast about an Australian man who was found guilty of his wife's murder 40 years after she went missing. Chris Dawson was charged with the murder of his wife Lynette in 2018 after the podcast, The Teacher's Pet, garnered global attention and prompted a renewed investigation. Mrs. Dawson's body has never been found. So, interesting stuff. Now, this is an indication of the possibility. I mean, I know Rick talked about this on his channel too, Hoglaw over there, on I think his Hangouts and Headlines and Hangouts, one of those, H&H. He was talking about this issue too, about the Adnan Syed situation. And I know that he was talking about the power of the podcast. And it does seem like there is growing interest in this area, particularly in true crime, right? And so that means that there's a possibility that some of these cases can have new interest brought into the forefront, where people start to dig into some cold cases and to try to get some resolution. Now we've also seen some scientific discoveries. Now, I'm always very hesitant about these quote unquote scientific discoveries, because we've seen in this particular case how sometimes what we think is revolutionary scientific technology can be unreliable. So we have seen how some cold cases have been sort of solved because of new technology having to do with DNA, particularly the Golden State Killer, who was triangulated because of a relative that had given their genetic material to be tested for, like 23andMe or one of those companies, and that was enough to sort of triangulate him with some of the DNA evidence that they had through these other incidents. And the thing that makes his case a bit more reliable with that is that they didn't use that to outright convict him. They used that to sort of find other corroborating evidence to then convict him. The problem is when we are relying too heavily on like new shiny technology that we think is reliable because it's new and because it's technology, and because as particularly talking about American society, we have a tendency to want to rely on these things because they feel more reliable if it comes from science, right? This is just kind of part of our culture. But things like lie detector tests are totally unreliable. The fact that they used that in this particular case to rule out some suspects is really, really unfortunate. And that I think is just it's just one example of why we have to be careful about junk science and about relying on junk science. And we talk about the issues with that in the court of law. And I think that also, to tie it back to earlier conversation about bot sentinel, we also have to be careful when we are relying on technology like that in the court of public opinion. If something has not been verified as reliable, if we don't know what the methods are for it, then we don't we don't know that we can accurately rely on that. And if we do, and we throw caution to the wind, what exactly are we going to be giving up in the process is a good question. Okay, let's go to our last subject here. All right, how many folks are here for Manson? For the Marilyn Manson case, we are talking about the latest filing in the not Ashley Morgan-Smithline, Esme Bianco versus Marilyn Manson case. So, if you have been following, there are a number of cases involving Marilyn Manson and DV claims here. So, there are a number of cases that were filed by women alleging things against him, and then he has a case where he has alleged defamation, intentional infliction of emotional distress, and a number of other claims against Evan Rachel Wood and Ilma Gore. So if you are familiar with this channel, if you've been following this for a while, you probably know all of this. But for those that are unfamiliar, another one is a case that was brought by the actress Esme Bianco. She was, I guess, most notably in Game of Thrones. I'm one of the, I don't know, maybe 12 people left on earth that has never seen Game of Thrones. So I'm actually not really familiar with her work other than I just know that she's in it. But aside from that, there are a number of other cases. One of them was brought by Ashley Morgan-Smithline, who is a model, and the two women are represented by the same man, J. Elwinger. And on the other side of the ledger, representing Marilyn Manson, I think at this point it is the same firm across the board on all of the cases. So it's the same lawyers kind of meeting across the aisle on all of these cases. It used to be that I think it was either in Esme Bianco's case or in Ashley Morgan-Smithline's case that Manson was being represented by one other firm, but I think they've gone out, and I think that it is the same attorneys now across the board. But what has happened? What has happened here is so in the Esme Bianco case, they have noticed or they have subpoenaed Miss Ashley Morgan-Smithline, who is a plaintiff in another case. She's not involved in the Esme Bianco case. She's a third party. She's been subpoenaed into this case for a deposition because what she has to say is going to be relevant to the claims and accusations in the Esme Bianco case. Now, Marilyn Manson's attorneys are also interested in that deposition for use in the Evan Rachel Wood and Ilma Gore case because they want to be able to use that to combat the anti-SLAPP motions that have been filed in there. So there's a lot of interest in this particular deposition. This was originally subpoenaed for sometime in August, and it wasn't until after the date that the deposition was supposed to happen that they learned that Ashley Morgan-Smithline had fired her attorney, Jay Elwinger. At least that's according to text messages from Ashley Morgan-Smithline and communications from Ashley Morgan-Smithline to Marilyn Manson's attorneys. Now, this all has played out in the motion papers for a particular issue having to do with this deposition. Now, it came about where J. Elwinger, Ashley Morgan-Smithline's ostensibly former attorney, filed a motion to modify the subpoena that is the mechanism for requesting Ashley Morgan-Smithline to get her deposition. They want to modify it to give her more time to ostensibly find another attorney so that she's not prejudiced in any way and that she has representation for the deposition because she has fired J. Elwinger. Or he has, actually, according to J. Elwinger, he says that he has withdrawn from representation from her. Maybe that's a distinction without a difference. Maybe not. For our purposes, it seems very, very relevant because of the fact that there are text messages that have been provided by Marilyn Manson's side in opposition to that motion. So Marilyn Manson's side has said, no, you can't modify this subpoena for a number of reasons. And in the process, they provided text messages from Ashley Morgan-Smithline indicating her conversations with other people, saying that she had fired him back in May. Also, they say that they had received a voicemail message from Ashley Morgan-Smithline saying back in May, saying that she had fired Jay Elwinger. So this was all in their opposition to the motion to modify the subpoena. Now, there is a reply that was filed on September 16th by Jay Elwinger as a reply in support of his motion to modify that subpoena. So this is what happens in the motion process. So this is always what happens, right? You have a motion. The other side has a certain amount of time to file an opposition if they want to oppose it. Not every motion is going to be opposed, but if they do, they have a certain amount of time to file an opposition. They talk about all the reasons why they are opposing it. This is why, these are the facts. This is the law that supports our position. And, everything that they're asking for or certain things that they're asking for is BS. And so therefore, Your Honor, don't give them what they're asking for. Then after that, the side that is asking, the moving party, the side that has filed the initial motion, they have a certain amount of time to file a reply to the opposition, or a reply in support of their motion. So you can call it one thing or the other. It's basically reply for short. So we have this reply that has been filed on September 16th. And this is what happened. So he says, in short, that he was never fired, and that any communications that she made, that Ashley Morgan-Smithline made to opposing counsel around May, were privileged communications, and that this implicates them in a professional responsibility kind of way. Interesting. We're going to go through this, the whole thing. It's not really that long of a reply, which replies tend to be a bit shorter. But so we're going to go through the whole thing, and then we're going to talk a little bit about the California rules of professional responsibility. So let's get into it. Here it is. This is the reply. Reply in support of third-party witness Ashley Lindsay Morgan-Smithline's opposed motion to modify subpoena. So remember, she's a plaintiff in her own case, but she also is a third-party witness in Esme Bianco's case. But they can use her deposition across the board in all of these cases, because she's still taking the same oath that she would take, as if she were speaking in trial, and she's able to, or they're able to use that against her in any context. Third-party witness Ashley Lindsay Morgan-Smithline, quote unquote Miss Smithline, by and through her attorneys, submits this reply in support of her opposed motion to modify the subpoena. In support thereof, Miss Smithline submits the following. It's interesting that it says by and through her attorneys. Didn't they already say that they had withdrawn? There are certain things that they can do, that a lawyer can do to represent a client that has fired them in order to have a smooth process. But it's interesting that they're still saying that they are her attorneys here, which is not really the case, but to a certain extent, I guess I don't know. Maybe I'm just being nitpicky. Also, hey, Nurse Liz, how's it going? Happy to see you here. She says, I feel like I need one of those cork boards for the case who is connected to who, and who is suing what in that what lawsuit. I know this is a really, really complex cluster of cases. I probably should have a video at this point. I think I'm familiar enough with all the different cases that I feel like I can probably put together the cork board with all the different like red lines, kind of like the little red threads, like what Charlie uses in It's Always Sunny in Philadelphia. There's that popular gif of him like in a cigarette, like pointing to like all the different things and like a conspiracy theory. I think that I'm at the point now that I can really start to pick out where these different individuals connect with one another, and to kind of talk about like, okay, this is just the basics so that you can understand like where do these all fit together. And Nethstar, yes, I pronounce it GIF because that is, I respect the creator of the technology who has said that it's pronounced GIF and not GIF. I know it's an unpopular opinion, but I know not everybody feels that way. Anyway, let's get back to this. Okay. Background, part 1. Throughout its opposition, defendant and his counsel hurl spurious insults based on incomplete or wholly inaccurate information, attorney-client privilege communications acquired by dubious and inadmissible means, and a basic misunderstanding of how one of the most popular social media platforms actually works. The shade. There's some massive shade here. None of their purported quote-unquote evidence, he's going the Bouzy route, by putting quotations around the word evidence to indicate that it's not really evidence, is grounds for denying the relief sought by Ms. Smithline's motion to modify the subpoena. As defendant's counsel has known throughout the pendency of this briefing process, the undersigned counsel filed a motion to withdraw representation for Ms. Smithline in Smithline v. Warner et al., which is also pending before this court. Now, it seems that it looks like it's not only the same lawyers that are involved in this particular case across the board, but also the same judge that is hearing the different cases. So that is also very interesting. Not necessarily uncommon, because oftentimes when you have similar cases that are operating under a similar fact pattern, similar but different enough that it requires them to be litigated separately, oftentimes you'll have the same judge that is overseeing both of them to make sure that they're sort of fitting together so that there is less waste of resources in litigating the cases. So you can kind of make things a little bit more efficient sometimes when you have the same judge that is sort of managing the development of the litigation of multiple cases that are related to one another. Um, just like I said, to prevent waste, ideally to prevent waste. Defendant filed its notice of non-opposition in the same case on September 6, 2022. Despite this acknowledgement, defendants and their counsel continue to press for information in connection with this motion that is still protected by the attorney-client privilege, and demanding answers to questions which can only be ascertained by the divulgence of attorney-client privilege information. This we cannot do. However, all information provided to counsel for defendants and every action taken by the undersigned counsel in connection with the subpoena that is the subject of this motion was taken in response to direct written instructions from Ms. Smithline, which pursuant to California law may be produced for in-camera inspection by the court. So that the court may have a complete understanding of the circumstances which led to the filing of this motion, we request an in-camera inspection of these documents by the court. So what are they asking for? They are asking for the court to do an in-camera review of a bunch of text messages between Ms. Smithline and Mr. Ellwinger, her attorney, her former attorney, ostensibly. And what does that mean? In-camera review means that they basically come to court, they have the text messages, they put them in front of the judge and they say, we are not going to file this on the docket because they are particularly sensitive. We don't, this is privileged information. However, Your Honor, this is just so that you can see this is not to disclose this information to the public because it's privileged, but this is to show you, that we are, that this is up, this is down. So that way it basically, this is what they will do when there is sensitive information that the court kind of needs in order to make a determination on something, but that way it doesn't make it public access. So anything that is filed on the docket is public information. I'm able to download it. Other people are able to download it. And unless it's filed under seal, in which case, as we know very well, if you've been following this channel through the Johnny Depp versus Amber Heard defamation trial and afterwards, that documents can also be unsealed. So when it comes to privileged information that falls under specifically like the attorney-client privilege, for example, that privilege outlasts the litigation. It lasts for basically the life of the attorney, that they are supposed to keep those confidential. Part 2, argument. Subpart A, defendant's counsel's failure to disclose communications. In the opposition and related declaration, defendant's counsel discloses for the first time that in May, Ms. Smithline left voicemail messages for Mr. Warner's counsel stating that she fired Mr. Ellwinger. So she referred to who she referred to as her former attorney. Those voice messages were never produced to Ms. Smithline's counsel, nor was even their existence disclosed. While it is true that defendant's counsel did call the undersigned counsel on July 1st, 2022 to confirm that Ms. Smithline was still represented by counsel and offered to settle her case, he never disclosed that she was the source of his information, instead vaguely referring to unnamed parties as the basis for his opinion. Counsel's duty to disclose this information was made clear by his own admonition on August 30th, 2022, when he wrote to Ms. Smithline and said, "As long as J. Ellwinger is your counsel of record, I am not permitted to communicate with you absent his consent." According to defendant's counsel's own sworn statement, he received voicemails from Ms. Smithline in May 2022. He then determined that Ms. Smithline was still represented by the undersigned counsel when he asked if the undersigned counsel could accept a subpoena on Ms. Smithline's behalf. Once it was confirmed that Ms. Smithline was still represented by counsel, that made the existence of the voicemails a disclosure of privileged attorney-client material. We do, however, hold that whenever a lawyer ascertains, okay, hang on a second. Let's back up before we get into the legal support that he points to. Okay, what he's saying here is that apparently Miss Smithline left a voicemail for Manson's attorneys saying that she had fired Jay Elwinger, that he was her former attorney. And this is what prompted them on July 1st to kind of question, to say, hey, are you still on the case? Are you still representing her? And so what Elwinger is saying is that they had a duty to inform Mr. Elwinger of that voicemail message that she had left. And particularly when there was confirmation from Mr. Elwinger that he was still, in fact, her attorney. And now he's saying that is privileged attorney-client communications. The voicemail that she left for Manson's attorneys is privileged attorney-client communications. That is what he's saying. And the reason why he says is he points to this as support that says, we do, however, hold that whenever a lawyer ascertains that he or she may have a privileged attorney-client material that was inadvertently provided by another, that lawyer must notify the party entitled to the privilege of that fact. Okay, now this is true. This is definitely true. If let's say I am representing Johnny Depp, and I've got Elaine Bredhoft across the way, and there's some sort of a note that I see on my desk. I think it's for me. I open it up. It turns out this is a note that was written by Amber Heard to Elaine saying, Elaine, turn your mic on. Or maybe something a little bit more material to the case. If I read that, the moment that I have any sort of context that this is not for me, but this is for opposing counsel and this is by their client, I am required to stop reading immediately, hand it over and say, I don't know how this landed on my desk, but this landed on my desk, and here you go. This is for you. I'm not using this, and you're supposed to be very forthright and give that over right away. So that is true. As soon as you have any inclination that you have just received privileged communications that were not intended for you, but were intended for opposing counsel by their client, that is absolutely the case, that you are supposed to provide that, and you're supposed to notify them of the privilege. But, and Rose Harvey, you're right there. You see where I'm going with this. That phone call that was left by Ashley Morgan-Smithline was not in fact left for Jay Elwinger, was it? That phone call was intended for Marilyn Manson's attorneys. That was if let's say that voicemail said, Jay Elwinger, you're fired. I'm firing you. I want to fire you. You suck. I hate you. Get out of my life. That is a privileged communication, arguably. But if she's saying, hi, Marilyn Manson's attorneys, I'm calling you to let you know I just fired Jay Elwinger and I want him out of my life and I don't want him litigating my case and I need to find a new attorney. That is different. That is very different. So that is a communication that is not between her and her attorney. That is a communication that she has sent to the opposing party. Now, so does that fall under the attorney-client privilege? No, it does not. It does not, because she has directed that communication to someone other than her attorney. And based on the context, it sounds like it was very clearly so. So is that privileged? Is that privileged communication? No. They are not under the same duty to inform Jay Elwinger of that voicemail as if it were her thinking that she was calling Jay Elwinger. That they don't have that duty under this authority. So this authority is irrelevant here. Now, do they have a duty to disclose for some other reason? That's another question. So we can look at the California bar's rules. Now give me one second here as I try to do two things at once, which never goes well. Okay. So here is I pulled the California State Bar rules on, whoa, extreme close up. Okay. On communications between attorneys and represented parties, because so in the context of this voicemail back in May, right? So you have a voicemail from Ashley Morgan-Smithline to Marilyn Manson's attorneys. Up to this point, she has been represented by J.L. Winger. This is the first notice that they have from her saying, he's no longer my attorney. They don't know for a fact that that is true. So for all intents and purposes, like this, the safest way for them to treat this is that she is still represented by him, because they don't know what kind of communications she's actually had with him. So they would be arguably bound by the rules of based on what they know at that point, what they are, I'll just say based on what they know at that point, they're bound by the rules having to do with communications with a represented person. So let's go through some of these rules to sort of clarify what are their obligations under that kind of a context. So part A says, in representing a client, the lawyer shall not communicate directly or indirectly about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer. So we're talking about they cannot talk about directly or indirectly about the subject of the representation with the person that the lawyer knows to be represented by another lawyer in the matter. The subject of the representation. Basically, this is intended so that lawyers don't try to poach clients from other people, from other lawyers. They don't want lawyers to sort of like try to sneak in through the back door and try to take away clients from other lawyers, because that can put clients in a very vulnerable position, because then you have a lot of people that can potentially be bad actors, trying with very slimy tactics to get clients in various ways, and they can potentially do. I'll just leave it at that. That they can do all kinds of slimy things to try to get a client if they were able to just sort of slide in there like that. It's much safer for the client to have the all other lawyers that want to talk to that client about their representation in a particular matter to talk through that lawyer first. It's a much safer thing for the client every time. Now, so that's the rule. It doesn't prohibit communications with a public official, board, committee, or body, or communications otherwise authorized by law or court order. So that's the rule, but what exactly does that mean? So the California rules of professional conduct also have, and this is the professional conduct rules in pretty much every jurisdiction. Every jurisdiction that I know of has comments in addition to the actual rules. So where they basically go through and give a little bit more context, like what is it? What exactly does this mean? So here, okay, so here, like let's take a look at some of these comments here so that we can sort of flesh out what exactly that means. This rule applies even though the represented person initiates or consents to the communication. So the fact that she reached out first doesn't mean anything for it doesn't lessen the professional responsibilities of Manson's attorneys here. A lawyer must immediately terminate communication with a person if, after commencing communication, the lawyer learns that the person is one with whom communication is not permitted by this rule. So you could be a lawyer that is talking to someone just on the street, and somehow conversation goes to a particular issue that they're having, and they go into their case and they start telling you this and that and this and that, and then they're like, yeah, and my lawyer said this. If you're the other person in that conversation and you are a lawyer, you have to kindly cut that off and say, I'm so sorry, I can't talk to you about this without consent from your lawyer. So that's how that plays out. Comment 2 says subject of the representation, matter, and person are not limited to a litigation context. This rule applies to communications with any person, whether or not a party to a formal adjudicative proceeding, contract, or negotiation, who is represented by counsel concerning the matter to which the communication relates. So this includes business transactions, contracts, all that kind of stuff. It's not just litigation. Now, comment 3 here says the prohibition against communicating indirectly with a person represented by counsel in paragraph A is intended to address situations where a lawyer seeks to communicate with a represented person through an intermediary, such as an agent, investigator, or the lawyer's client. This rule, however, does not prevent represented persons from communicating directly with one another with respect to the subject of the communication. Of the representation, nor does it prohibit a lawyer from advising a client concerning such communication. A lawyer may also advise a client not to accept or engage in such communications. The rule also does not prohibit a lawyer who is a party to a legal matter from communicating on his or her own behalf with a represented person in that matter. So if a lawyer is representing themselves as a party to litigation, they're able to talk with other people that are represented because that lawyer is not acting as a lawyer, they are acting as a party for themselves. Now, but more important than that, what we are talking about here, all of these comments are talking about a lawyer actively communicating with a client. There is nothing here that we have come across that says anything about the lawyer having a requirement to tell opposing counsel that they have had a conversation or that they have had communications from the client. This does not actually technically prohibit the client from communicating with opposing counsel. If there is now indirect conversation, or that the lawyer involved, the opposing lawyer involved, is setting things up in such a way so that there is sort of like not direct conversations, but kind of circling around stuff. That's where you get into professional responsibility areas. But where there is one piece of communication by the client, by the opposing client, to the opposing lawyer, and there was no response from them, and there was no further communication from the opposing party, that is not running afoul of the professional responsibility rules, in my opinion. This is just my interpretation of the rule and of the comments. Now, best practices, on the other hand, indicate, yeah, you probably should tell opposing counsel just to make sure that all of your I's are dotted and your T's are crossed. But in terms of actually if this gets put in front of the bar as a bar complaint, I don't see Manson's attorneys running afoul just by never responding to the voicemail and never saying anything to Jay Elwinger for it. So in other words, all of that is to go through the line and say, did they have an ethical obligation to tell Jay Elwinger that they had gotten a communication from Ashley Morgan-Smithline? I don't think so. Personally, I don't think that they had an obligation. Would it have been good? Yeah, it absolutely would have been. It would have been. I mean, it's like I said, best practices, right? You always want to lawyers, generally speaking, when it comes to professional responsibility requirements, we tend to be overly careful because no one wants to lose their bar license, especially for something stupid. So we tend to be overly careful for this kind of stuff. Okay, let's continue on. Part B, the retainer agreement is privileged. On footnote 2 of the opposition, defendant argues that retainer agreements are non-privileged and that I think they mean moreover, if Ms. Smithline terminated Mr. Elwinger in April 2022, none of their communications since are attorney-client communications. And that would be true. That would absolutely be true. That you can't shield communications under the attorney-client privilege if the attorney-client relationship has been severed. So communications after that point are not privileged. Ms. Smithline did not terminate her attorney-client relationship with the undersigned counsel in April 2022. And further, a written fee contract shall be deemed to be a confidential communication within the meaning of subdivision E of section 6068 of section 952 of the Evidence Code. Okay, so he says Ms. Smithline did not terminate her attorney-client relationship. in April 2022. And for some reason, he's referring to the retainer agreement. Now, I agree that the retainer agreement is privileged. That is something that is a privileged communication between the attorney and the client. That's a contractual agreement between them that indicates what they have agreed to within their attorney-client relationship. Um, but what does that have to do with proving whether or not she fired him in April 2022? I don't know. Now, they've got this footnote 1 here, which says, again, this fact may be conclusively established by an in-camera review by the court, which is hereby requested, of the over 500 messages exchanged directly between Ms. Smithline and the undersigned counsel from April 2022 to August 2022. So over 500 messages between the two of them. He seems to think that they would show that, I don't know, maybe she fired him and then rehired him. That's always a possibility. She may have fired and rehired him several times, in which case that relationship may have had a couple holes here and there, but on the whole, he was mostly representing her, it seems like. Part C, defendant relies on inadmissible and inaccurate information. In its opposition, defendant states that Ms. Smithline sent a number of Instagram messages to a third party stating she fired Mr. Ellwinger in April 2022. Shockingly, defendants make no effort to identify who the source of these messages are, other than to say a third party. The included screenshots do not even reveal the purported owner of the Instagram account with whom Ms. Smithline was allegedly communicating, and there's no indicia of trustworthiness or reliability to overcome exclusion of this evidence under Federal Rule of Evidence 801. I mean, I think that there probably is a way to evaluate these text messages, and not just outright exclude them. Basically, what he's saying is because of the fact that that Manson's attorneys didn't indicate who the third party was that communicated with Ashley Morgan-Smithline, to whom she said that she had fired him. Yeah. I mean, I would agree that that's relevant. It's important to know that. It's important to be able to evaluate that information as to whether or not those messages are trustworthy. However, she kind of said fairly unequivocally in a number of contexts saying that she had fired him, and this is at various points in time. Now, do we trust the metadata behind those screenshots, behind, like showing those text messages, do the dates and timestamps of those messages? Yeah, obviously having those backed up by metadata is incredibly helpful. And ideally, it is a good idea to have, when you are submitting text messages like that, to include with them a declaration from the person that actually communicated with her in those messages. That is always going to be much, much better. But does that mean, does the fact that the that information isn't included in there, does that make it completely unreliable to the extent that you can't exclude, or that you have to exclude these messages? I don't think so. There's still ways to provide circumstantial evidence for it. The trustworthiness of an out of court statement is assessed by the circumstances surrounding the making of the statement. An unexhaustive list of potentially relevant circumstances includes the following: the relationship, if any, between the declarant and the person to whom the statement is made, whether the statement is made under oath, whether the statement is made voluntarily and or spontaneously, whether the statement is based on personal knowledge, whether the statement is made in anticipation of litigation, whether the statement contradicts or is consistent with the declarant's previous or subsequent statements, whether the statement is self-serving or against the declarant's interest. And I'm going through these very quickly because most of these really don't matter for this particular case. In terms of legal writing, a lot of this paragraph really could have been cut out, and he could have cut right to the chase. The declarant's motive in making the statements, including any possible bias or incentive to lie, the extent to which the jury will have the opportunity to evaluate the declarant's credibility, the reliability of the declarant's perception or memory, and his or her history of truthfulness, and the statement's proximity in time to the events it describes. I mean, most of these things we're talking about Ashley Morgan-Smithline. She's the one that made these declarations in these text messages. So we're not talking about an unknown entity that is making these statements. these are statements that the ones that are at issue were the ones that were made by the party, by the individual, by the client. So a lot of these are less relevant. Defendants have not made any effort to establish any of the above circumstance, and this evidence must be excluded. I don't think that necessarily means that it should be excluded. Maybe request to have more circumstantial evidence provided before that point. Additionally, in its opposition, defendants states that Mr. Warner's counsel also asked whether Ms. Smithline was in fact in Los Angeles, as it appeared from her Instagram account that she was still in London. Assuming arguendo that the basis of this opinion was a post from Ms. Smithline listing London as her location at the time of the post, defendant's counsel seems unaware that Instagram allows its users to list any location when posting photographs, regardless of whether they are actually located at the time of the posting. For example, the moon is an acceptable location tag in the app, although presumably none of the users who post photographs on Instagram from the moon are actually located on the moon at the time of their posting. This guy loves quotations as much as Bouzy does. Anybody else feel that way? The shade, right? There's so much shade in this that he's basically saying clearly opposing counsel does not understand Instagram, that you don't have to be in the location in which you are tagging yourself at the time you are tagging yourself there. However, I mean, I remember how this was brought up in the opposition, and they were basically saying, look, we saw that tag in that post around the time of the deposition, and that brought up a legitimate question. Is she in the area? Is she in London? Where is she? So, this sort of like, I feel like this is like blustering in response to be like, oh, clearly you don't know how Instagram works. Clearly you don't know any of this stuff. So, let's talk about the moon. Let's talk about how people don't actually post Instagram posts from the moon. It's just, it has a certain spice, a certain attitude that is interesting, and it feels like it's coming from him feeling like he's definitely on the back foot, having to do with, I don't know, maybe the fact that he's been implicated with his bar license, with his communications that have been published between him and his former client, right? There was a lot of questionable communications coming from him to his own client that was very, very interesting, to say the least. Part D, the relief requested on behalf of Ms. Smithline is reasonable. Pursuant to Rule 45D3A, a court is required to quash or modify a subpoena if it fails to allow a reasonable time to comply, requires a person to comply beyond the specified geographical limits, requires disclosure of privileged or other protected matter, or subjects a person to undue burden. In determining whether a subpoena poses an undue burden, courts weigh the burden of the subpoenaed party against the value of the information to the serving party. Defendant subpoena in its current form places an undue burden upon Ms. Smithline. Ms. Smithline would be forced to testify at a deposition, either unrepresented or represented by counsel who has already filed a motion to withdraw from representing her. Additionally, the parties deposing her are the very same parties she has asserted claims against in her own lawsuit, represented by the same attorneys. Allowing the subpoena to stand in its current form would heavily prejudice Ms. Smithline. Okay, so I don't know if this is going to be enough for this. Okay, so he's saying that the court can modify the subpoena if it's going to unduly burden the opposing party or the third party witness, what have you. Now, when we're talking about undue burden, we're talking about oftentimes things like they've noticed a time and a place that is really, really hard for that witness to come to the deposition. They're on the opposite side of the world. They can't possibly be there in person, and the attorney that's deposing them is requiring them to be in person. Massive expense, massive like time involved. Like that's an undue burden. When we're talking about the threat of her either having to represent herself or to have J. Elwinger represent her for the purposes of the deposition, they can also say, she can also say, hey, I'm just going to represent myself here. And she has a right to do that if she wants to do that. Is that wise? I wouldn't think so, because there's a whole heck of a lot of ways that she could be sort of put through the ringer without sort of realizing what sort of trip lines she would be tripping over, until she's actually tripped over them. Um, so there's a lot of things that could go wrong with her representing herself in the course and scope of a deposition. But at the same time, I think, but if she really wants to, she can. That's not necessarily an undue burden. Um, and it's also not an undue burden to have her former counsel represent her for limited purposes for that deposition, because even though she's fired J. Elwinger, she can still say she can basically rehire him for the limited purposes of that deposition. She can say, "Hey, look, I'm firing this guy, but I'm hiring him just for this deposition, and after that, he's out. He's done. I'm done with him." So she can do that. That doesn't pose an undue burden for her. Um, but he claims that allowing the subpoena to stand in its current form would heavily prejudice Misogyny. And, a judge might disagree with me on that. It depends on how tough this particular judge is. We're talking about a case where the deposition was already supposed to have happened, right? And they're modifying it after the fact. There are some judges out there that are going to put a really strict line on that and say, no, you had every opportunity to do it before the deadline. The deadline has long passed, and now you want to modify it, like after you were supposed, like after all of this time that you have now put the other side on the back foot by delaying and delaying and delaying. I'm not going to reward that. There are judges that would say that. There are also other judges that'll say, well, now we have a party that is not represented by anyone, and I don't want to put her interests, or I don't want to put her in a very vulnerable position because of the fact that her lawyer was a shitbag. Additionally, the modification requested would not impact the value of the information to defendants, nor would it burden them significantly, as the court recently extended all deadlines in this case by 90 days, including the deadline to conduct fact discovery. Allowing Misogyny reasonable time to secure adequate representation at her deposition ensures a fair and equitable proceeding and does not prejudice defendants in any way. Now, I think that Manson's attorneys probably would say otherwise, because they would probably say, yeah, actually, we are prejudiced because we were planning on using this deposition in another matter having to do with using that deposition to combat anti-SLAPP motions against us, and we are on a time deadline for that. This is going to significantly prejudice us in another case where this is relevant. So I would venture that at the particular hearing where they are going to be arguing about this motion, I would imagine that Manson's attorneys are probably going to argue something along those lines and say, no, 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 we are prejudiced. We're very much prejudiced. We could have an entire case against two other defendants, two other women that have accused our client of similar things to what Miss-Smithline and Miss Bianco have accused him of here. In another case, he can have his case against those women for defamation and IIED and all these other claims. He could have that case dismissed just by the fact that he doesn't have this information in time. He's on a time crunch in that other case. So yeah, this is going to significantly unduly burden him in that other case by having this delay. We can have all the other discovery conducted in this case. That's fine. We need this deposition, and we need this deposition as soon as possible. You can't reward the other side for gamesmanship by trying to modify this long after the fact, long after, there have been many communications by this client saying that she has fired this attorney months and months ago, and there was so much time for him to come forward and withdraw. And then he does this after the deposition was supposed to happen, and then trying to modify, he's improperly using the justice system is what his attorneys could argue. Would that be a winning argument? I don't know, because the court may look at those DMs and say, Elwinger's got something on you. I don't see who who these communications are with between Ashley Morgan-Smithline and this other person. Like, I want to know more information. How reliable is it? When actually did this representation end? You know, and maybe they'll want to have a small evidentiary hearing on that to figure out some of these issues. I don't know. I don't know. But it's certainly not a slam dunk for Manson's case, but I could see the court saying, you know what, we've already said 90 days for all of the other discovery, so not much of a harm in that. And, you know, in that other case, maybe you can get some delays in that other, I don't know, the other case. I don't know. I don't know. But we will see. We'll see what happens. This case is, I can't remember when I think it should say on the first page, perhaps, when the hearing is September 30th. September 30th, 2022 is the hearing at 1:30 p.m. In Los Angeles. So we'll see what happens. We'll see what results from this after that hearing. And I don't know. What do you guys think? Do you think that it's possible that she only recently fired him? That maybe Elwinger is telling the truth? Do you think it's possible that maybe she fired him and then rehired him a number of times? I think that honestly is totally possible as well. She could have fired him, called Manson's attorney saying, I just fired him. Screw that guy. I hate him. I want him out of my life. And then the next day he kind of comes back to her and says, please hire me back. Please hire me back. Please hire me back. And then she says, okay, fine. And then she doesn't like send another communication to Manson's attorney saying, just kidding, I just rehired him or something. Like, she wouldn't be under any obligation to do that. But like, I can see something like that happening in this case. And especially if you have somebody that has a volatile relationship with their attorney. And when I say volatile, I don't mean violent. I mean one that is positive, negative, positive, negative. You've got all of these different kinds of interactions. You're frustrated with your attorney, and then you're happy with your attorney. You're frustrated with the process, and then you think that your attorney is not doing the job that they're supposed to do. They're not litigating the case, you know, as vigorously as you would have thought that they would. There are all kinds of reasons why that relationship could get strained. But I don't know. What do you guys think? Let me know in the chat. Let me know in the comments down below if you're watching on the replay. But otherwise, that's all that I've got for today. I really appreciate you guys hanging out with me today. I know that this was a long one. We went through a bunch of subjects here, and I think that this is there's a lot of interesting stuff happening. But let me know what you guys think. And otherwise, Thursday, 10 a.m. East Coast time, we've got Latest in the Law coming out. Nate the lawyer said that he will be on with me. I might have some other folks with me as well. And otherwise, I will see you guys in the next bit. Wait, before I say that, thanks again to everybody in the chat. Thanks again to the mod, Secret McSquirrel. You are the best. You literally went to the hospital and you're like still back. I mean, you're back. You're back and modding the chat as brilliantly and beautifully and wonderfully as well. I appreciate the heck out of you. And I appreciate all of you guys in the chat as well. So thanks to everybody for tuning in. And I will see you guys in the next video.